Hey, everybody. Thank you for joining us. This is We the Patriots USA Constitution course. One more time, we have a special guest tonight, Brian Festa, Vice President and co founder of We the Patriots, is going to join us. We're going to talk about a bunch of things constitutional and things that have come down in the Supreme Court. So, with that, let's bring Brian on and we will get this rocking and rolling. And I'm going to be on the right side no matter what.
Yeah, I was trying to get it switched, David, so that I could, because since I'm not, when I'm the host, I'm usually on this side, but since I'm logged in as a host, I guess it's forcing me to be on this side. So
it doesn't know different.
yeah, it doesn't matter. Thank you for having me in the class. I always love joining the Constitution class, and yeah, tonight we're going to talk about some exciting things, some good, some bad. As usual, it's a mixed bag from this last session, the major decisions that were handed down. They call it the Major Decisions Week, usually, when the last week in June, when all of the big decisions come out from the Supreme Court. We had a lot of those this year, really, really big decisions. I know it's been about a month now, but I haven't had a chance to come on and really talk about them. So I think whichever you want to start with, David, there's election integrity, there's trans athletes, there's birthright citizenship, there's cell phone data, Fourth Amendment stuff. We can talk about all of it.
Well, let's do the lowest hanging fruit and take the Title IX and the trans athletes and all of that sort of thing, because that was an easy one. Should have been. What were your thoughts about that decision?
Yeah, well, I mean, like you said, it should have been. I mean, honestly, David, it's a decision that we shouldn't have needed, right? I mean, this is something that shouldn't have had to be a Supreme Court case, a lawsuit. I mean, this is something that 20 years ago, or maybe even less, it was just something that we all knew, right? That that males, biological males, cannot play in female sports. Okay, and what the court said here, the court did not actually say that. The court did not say that males, biological males, cannot compete with females. I wish we had a decision that said that, but we simply had a decision that saying a ban, if a state bans that it is not, it does not violate Title IX. So what was at issue here was West Virginia and Idaho, the state where I now reside and where We the Patriots USA is now headquartered, they passed statutes that prohibit biological males from participating in women's sports. And so the decision, which was West Virginia versus BPJ, in that decision, the court found, and by the way, it's important to note that no justice fully dissented from this decision. There were concurrences, there were maybe some different thoughts. I would have maybe reached the decision a different way, but no justice fully dissented from the decision. The judgment firmly establishes the ability of states to pass laws that keep biological men out of women's sports. But importantly, they did not say that states cannot enact laws allowing biological males to participate in female athletics. And the reason was, what was at issue here, what was before the court, the question presented, as they call it, was simply whether Title IX, which is the federal law that mandates equal opportunities for women in college sports and in education, in all educational programs and activities, not just athletics, but that's the context it most often comes up, and whether the Equal Protection Clause of the 14th Amendment allow states and schools to ban biological men from women's sports. And the answer was, I'm pleased to say, was a definitive yes, that it does not violate Title IX. Actually, Title IX fully allows this. It's fully permissible under Title IX to have statutes like that. So we have, similar to the Dobbs decision, where the Supreme Court didn't say that abortion must be illegal everywhere. That's not what they said. They simply said that states that they left it up to the states. They returned the question to the states. And a similar thing happened.
Like states get a question, have the right to a question, but that's a separate topic.
Well, that's what they held. This is
Right.
States can do what they want when it comes to this. This is not something, um, you know, honestly, I mean, this isn't something the federal government should be deciding, you know, anyway. If we could talk about federal powers, and as we often talk about in this course, as you often talk about, especially, is the limits of federal power, and the
Right.
federal government is really like that, right?
Right.
And the power of the people is supposed to be like this, right? Um,
Sure.
the power is reserved to us that we retain, I should say,
Right.
is supposed to be very, very great. And this limited scope of federal authority that we've granted, even that authority has been granted by the people to them.
Right.
The federal government didn't declare that their territory. They think they did. They think
Right.
they staked their claim to these rights, these powers. I mean, no, we gave you those powers. We've said
Right.
you can do this. You can do these things. We're okay with it as a people, but the rest
Right.
is supposed to be reserved to us. So, it's kind of, I wrote a Substack about this, and I said that it's kind of baffling that we needed 77 pages of opinions to decide what should be a simple question here, right? Because even without
Right.
the 14th Amendment or Title IX, I mean, this is common sense. Of course, biological men should be banned from women's sports. Common sense and basic biology provide a readily apparent answer to this, right? As I said in my article
Right.
that I'm glancing at now, even without courts, even without constitutions, this is something that everybody should know.
Right.
But we live in an age where a Supreme Court justice can't answer the question, "What is a woman?" because she's not a biologist,
Right.
right? So anyway, I mean, I think it was a good decision. Obviously, I agree with the decision. I think it should have been
Right.
broader.
Right.
But the good news is, if you live in a state like Idaho or West Virginia or any other state that's passing laws like this that wants to keep biological men out of women's sports, you're allowed to do that. The states are allowed to pass those laws. Doesn't violate any federal law or the Constitution. You're allowed to do that. And hopefully more states will do it. I don't know what's happening in Oklahoma, but
We've never had a problem with it. We don't do it here. So I think we already have a ban on it. Um, it's just not been an issue. Hey everybody. Sorry about that. I don't know if you could hear the audio. We were having troubles. We've got uh some problems here in the background. We're going to try to get everything back. We had to record this earlier in the week or late last week uh to try to make up for this because Brian gets real busy this time of evening. And so we're going to try to get that back. So we're working on that, and because our discussion was a lot of fun, and I hope that we can have the full discussion. um, and so as we go, I may just get cut off. Brian can um, just interrupt me and we'll go from there. But thank you everybody for joining us. Again, this is We the Patriots USA. I don't know where everybody's coming from. I loved the comment uh, that put up here on the screen that isn't there only one kind of males? The addition of on biological seems redundant. Amen. We agree. Both Brian and I agree with that. We don't use the preferred pronouns, the lying pronouns and things like that. I don't think either one of us. I know I certainly don't. And so that's everybody's prerogative how they want to live it. I will not participate in a fraud, and so that's where I come from. So thank you for your comment on that. The um, somebody's from Boise. We've got people who could be tuning in from all over the country. Um, Word went out to New Jersey, North Carolina, New York, as well as California, Texas, Idaho, of course, Oklahoma, where I'm at. Uh, just to give everybody a little bit of an idea who we are, if you're not already familiar, We the Patriots USA is a public interest law firm. They do everything free of charge to those plaintiffs they pick up, and they are working in the public interest. In other words, that the cases that they take will have widespread interest to the public. And so we are fighting cases that are going to the Supreme Court. We are doing all sorts of things all around the country. And Brian would have to tell you about all the details, but that is what we do. And anyone who signs up and donates to We the Patriots USA, that's what you're doing. You are participating in that. Now, we have been fighting um, vaccine mandates and so forth since before it was popular. Hey, everybody. Thank you for joining us. This is We the Patriots USA. And I don't know if I got cut off or not.
Okay, David, can you hear me?
I can.
All right. I'm sorry to interrupt. We're going to try to do this again. We're about 11, 12 minutes in or further.
Try. Yep. You can go there. We were about 9 minutes in or so.
All right. I'm
got
going
cut
to try. I'm going to try this again. Sorry, folks.
We just don't do it.
Yeah. Like the 3 months rule one way have started consistently going the other way, and other justices even that you think you're going to rule one way have gone the other way. So we've seen some really weird majorities here, really weird combinations, but I guess it shouldn't surprise me anymore. Right. Well, so this is a decision, Trump versus Barbara, that, believe it or not, only 3 justices fully dissented from this decision. That was the usual suspects, Justice Thomas, Justice Alito, and Justice Gorsuch, okay, who have been like the 3 musketeers on the Supreme Court. In my opinion, the 3 best justices we have in the Supreme Court. Would you agree?
Yeah. I had Gorsuch hands down until the decision that's so bad for us here in Oklahoma.
Yeah,
What's that?
yeah. Oh, I was thinking of the
McGirt,
I was thinking of the transgender employment decision, but
well, there's that too. But no, it was the McGirt decision was so bad, making Indians turning parts of Oklahoma into Indian country, but Gorsuch still is right up there.
Well, he is. I mean, I don't agree with the decision. It's escaping me the name of the decision, but the employment, the Title VII one that I just referenced, where
right.
he said that sex in Title VII is intended to encompass sexual orientation and gender identity. No way. The Congress, no way, when that was enacted, had any even the slightest inkling of including that. And quite frankly, the plain language of the statutory construction, if we're going to interpret statutes to mean what they say they mean, there is no way that the word sex has ever been in the history of mankind understood to include one's sexual orientation or gender identity. So, if they wanted to amend that statute to include those as protected classes, they certainly could. But just to say that because the word sex is in there, anything, remotely that might have to do with sex or gender or, sexual identity or something.
The point is that none of that matters anyway. These whole protected classes, you and I've talked a lot about my problem with the Civil Rights Act and all of its various titles is that we have protected classes. Well, every American is a protected class. It doesn't matter what you do. You're an American. That is supposed to be the protected class.
Right. Which is why we need to add something like vaccination status or health status, which we've been petitioning. We have a petition still active on our website, folks. If you haven't signed it, please do tell others to sign it, because we've been trying to get to 100,000 signatures and we're a long ways off from there. But it's a petition to make health status a protected class under the Civil Rights Act. But we wouldn't need it if everyone were protected. The problem is when you start enumerating individual classes of people, then you've got to list every single group of persons that could possibly exist to be protected.
Exactly. And then if you're one of those that got left out, then where's your protections? Oh, you don't have any. And that's been the argument, because I have fit into, I've complained and I've gone to the Civil Rights Division. They're like, well, you're not a protected class. Excuse me.
You have to be named. Now it is broad in the sense that religion or religious belief, or even as it's termed in some statutes, some state statutes, creed is very all encompassing. That could be any belief, whether religious or otherwise.
Correct.
So I do like the use of that terminology when creed is put in there. It's in Title VII, it's religion, or religious belief or religion. But, again, that could be very personal. Anybody could have a religion, whether it's an organized religion or a personal one. But anyway, didn't want to get off on a tangent.
Right.
But those are those three justices, they're the only ones that fully dissented from this decision. Chief Justice John Roberts authored this decision, and I would call it President Trump's greatest legal defeat across both of his terms in office. Is the issue of, because he made the issue of birthright citizenship.
We lost you, Brian. We lost you. I think you bumped your mic or something. There you're back a little bit. Say something again.
Okay, can you hear me now?
You can. Yeah, you're back to being good. There you go.
All right, you can hear you.
Yep.
My speaker was off. Can you hear me now?
I can now. Yeah, you were
okay. Great.
in and out.
I can hear you. I'm sorry about that. I've been having issues with this microphone for a while, and I apologize. This was arguably his largest defeat across both of his presidential terms, in my opinion. I mean, he made birthright citizenship a huge issue in his campaigns. I think he talked about it in both campaigns. Did he not? This was part of his platform.
Yeah.
So
it has been.
So to lose this case at the Supreme Court was a huge blow to his presidency, to his administration. I think this decision was wrongly decided. I'll let you know why. But I'll tell you what Justice Roberts said. First of all, he declared that the 14th Amendment was intended to enshrine the English common law of citizenship known as jus soli, or the
Hey, everybody. Thank you for joining us. This is We The
I'm sorry about that. I've been having issues with this microphone for a while. This was arguably his largest defeat across both of his presidential terms, in my opinion. I mean, he made birthright citizenship a huge issue in his campaigns. I think he talked about it in both campaigns. Did he not? This was part of his platform.
Yeah.
So
it has been.
So to lose this case at the Supreme Court was a huge blow to his presidency, to his administration. I think this decision was wrongly decided. I'll let you know why. But I'll tell you what Justice Roberts said. First of all, he declared that the 14th Amendment was intended to enshrine the English common law of known as jus soli, or the right of the soil, which I'm sure you're very familiar with, David.
Right. We talked about it.
We talked about it in class before. And he also spent a considerable amount of space in the decision detailing that common law history. It's purported. I said it right the first time. It's purported preservation throughout American history. So he was making the argument this has always been a prevailing principle, and especially in the years leading up to the passage of the Civil Rights Act of 1866, the ratification of the 14th Amendment Citizenship Clause, which were both, as you know, David, responses, and I'm sure people listening are aware of this as well. They were responses to the terrible Supreme Court decision in Dred Scott v. Stanford from 1857, which denied citizenship to slaves and their descendants. Now, nobody today, no rational person anyway, would be arguing that Dred Scott was correctly decided. Everyone would agree that everyone should have, there should be a path to citizenship, a legal path to citizenship right. for any human being. The country, I believe, does reserve the right to deny that. But apparently, according to this Supreme Court, no. If you're born here, it's automatic. It doesn't matter how you got here, how your parents got here. It's automatic. To me, there's just so many holes in this. I mean, to reward people who are here illegally by saying, if you can make it in, if you can break the law and make it into this country and have a baby here, your reward is your child will become an automatic citizen. And right? All persons born or naturalized in the United States and subject to the jurisdiction thereof of the United States and of the state wherein they reside. But those five words, we talked about 77 pages in the other decision. Well, get ready, folks. Buckle up. 194 pages of opinion, concurrences, and dissents. Justice Thomas's dissent alone.
Hey, everybody. Sorry about that. We are having so many troubles. I do not know what is going on, but we are always experimenting around here. So I apologize, but we're gonna keep talking. Hopefully Brian can join us. I don't know if we're having internet problems on our ends of things or what, but we have had just nothing but problems. Thank you again for joining us. Constitution. We're talking about Trump v. Barbara. We had actually a real fun discussion that I wish you could have joined. Yeah, I'm sorry, Gail. The thing that is the sound still bad, everybody? If you could just type in a comment. If it's still bad, then we've got even bigger problems than we realize. And don't know where that would be. We think we've found some of the other problems, but it's not necessarily fixable tonight. But for us, let's just change gears. And what I'd like to do is, because we're doing this a bit cold now, I was okay, good. Thank you, Gail. I would like to know what you guys would like to talk about. Tonight we were speaking specifically about men calling themselves women and vice versa, and we were gonna talk about that. We were gonna talk about what was the other thing we talked about the other day? We were also talking about the what was it that we were discussing? Anyway, the point was that we can talk about whatever we want at this point, because we just went live, and so everything that we did do is now gone, and so we can talk about anything we want. Was going to be birthright citizenship. That was the Trump v. Barbara, and so the birthright citizenship. They got, in my estimation, they got wrong. And they did the same thing as, and I would still like to hear from you about what kinds of things you would like to hear or talk about. The problem with Barbara with that decision was, in my estimation, basically the same problem that they came up with in the Dobbs decision. That's the one where they said that they overturned Roe v. Wade. And here's Brian back. I think
Okay.
Brian's there. You go.
What I'm
You're
going to do,
you're on.
I tried to remove my other one. So let me just do that. Okay. Are we still live? Can everybody still hear me?
We are still live. We've got viewers.
I apologize for that. I know that was a little bit that was really frustrating. It was frustrating for us on our end as well, watching it and trying to troubleshoot. And this just goes to the point, ladies and gentlemen, I don't want to belabor the point. You know, David talked about how much we rely on public donations and everything. If we had the funding, we could have a video team.
We're pretty low tech here.
We could have production assistants. We could have people in the background that would be taking care. I could have a professional studio even. But this is what it comes down to. And people say, why do you need funding? Well, you just saw in real time one of the reasons we need it, because there's two arms to our mission here at We The Patriots USA. One is litigation, the lawsuits that we always talk about, but the other is education. Education is so important. Broadcast events like this, educating you about the Constitution and your rights. We need a professional studio. We need, at least, at the very least, professionals in the background that can troubleshoot and have this brought to you with high quality video and sound. In 2026, you should expect no less. Anyway, David, what were we talking about when I was cut off? Because I do want people to be able to hear this. I do want people to be, hopefully my video feed is better now. I made some upgrades with the equipment.
Perfect now.
Okay.
Perfect.
What were we talking about? Which Supreme Court decision? I'm winging this tonight because I wasn't prepared to go live tonight. I have a lot of other things kind of going on in the background, but I'm going to do my best just to jump in. What specifically, which decision were we talking about? Was it Trump v. Barbara?
We think it was Trump v. Barbara. I think we skipped around a little bit, but let's get back to Trump v. Barbara. I was just starting to share my my thoughts on it, but let's hear from you because that's where we were at. And then what I'd like to do is make sure that everybody's typing in your comments as we go, because if you have thoughts or comments or questions, we can put those on the screen and we can address those. So feel free to participate. This is a participation class and discussion. This is not just us lecturing. So
yeah, absolutely not. And for anyone who's interested in joining the Constitution class, maybe you're not after that debacle, but hopefully we can
usually go smoothly.
Oh, I mean, David has no problems. When it's usually just David, there's no issues. Every week we do it on a Zoom call. It's a private Zoom call for our premium Patriot members, and there's usually no issue. But anyway, Trump v. Barbara, I thought it was a really interesting decision because, you know, I didn't quite understand Justice Roberts' logic here. I couldn't really quite follow it. He gave some historical context. And as I think I said, I don't know if it played this part of the video yet, while on the one hand, what he was saying was historically accurate, the individual facts, I don't think he gave the proper context and explained everything, again, in the full perspective of the times. And he used a decision in particular, which was from 1812, I believe, Schooner Exchange v. McFadden, a very famous Supreme Court decision by Chief Justice John Marshall. You know, that was the basis of his interpretation of the phrase subject to the jurisdiction thereof in the 14th Amendment, which is where we get the idea, purportedly, the grounds for birthright citizenship. And in that decision, Justice Marshall specifically talks about what that means, but Justice Marshall's actual statement in that decision says, and I'm going to quote here because I'm reading it, all exceptions, therefore, to the full and complete power of a nation within its own territories must be traced up to the consent of the nation itself. They can flow from no other legitimate source. And so what I want to know is how exactly are persons who enter this country illegally here with the nation's consent? They're not, right? And, he spent a lot of time, or at least some time, criticizing Justices Thomas and Alito for focusing their attention on the Civil Rights Act of 1866, because that was passed 2 years before the ratification of the 14th Amendment, which has this, again, allegedly birthright citizenship clause in it. But at the same time, he's forming the basis of his interpretation on a Supreme Court opinion from 1812 that was 56 years before the ratification of the 14th Amendment. So you're saying, well, you're looking at something from 2 years before it was passed, so it's almost like it's not relevant, or you shouldn't be relying on that so heavily. Well, Justice Roberts, respectfully, I mean, you're relying on something from 1812. And so if close proximity in time to the ratification of the 14th Amendment is going to be one of your arguments as to why we should not look to, for instance, the Civil Rights Act of 1866, then I think we could make a stronger argument that we shouldn't be looking to this decision from 1812. And even if we do look at that decision again, how are persons here illegally here with the nation's consent, which is what Justice Marshall was talking about in that decision? They're not. So I don't quite understand it. I don't follow the logic here. Not trying to be disrespectful. It's just that I would have written it a different way had I been the Chief Justice or any justice. I probably would have written a 90-page dissent, as Justice Thomas did, maybe longer, knowing me, how long-winded I am. But
and to your point, that they then bring up Wong Kim Ark. For people who don't know, Wong Kim Ark was a young man whose parents came here with permission from China to, and then they lived out on the West Coast in San Francisco area, and were part of the growth of the West when we were bringing people in from China. So they were here for with permission, and then they left, not so much of their own volition, but because they felt forced out. There was a lot of violence, racial tensions and violence. And so they decided it was better to go back to China than stay here under that. Wong Kim Ark decided, I've grown up in America and I'm staying here. And they're trying to equate Wong Kim Ark as though he was the same as illegals, or the parents were the same as illegals. And directly to your point, there is no comparison. They're apples and oranges.
Right.
And so, if somebody comes here and wants to be an American and begins a naturalization process, assuming there was one at the time for Chinese immigrants, but if they're doing that and then they have a child, that's a completely different story. A completely different story than somebody coming here for birth tourism, or just make it across the border, plop a baby out, and then now everybody's an American.
Right. And Justice Gorsuch brings up, those four Wong Kim Ark exceptions that have historically been only recognized. I won't go through them here right now. I don't want to get too deep into the legal weeds, but he says that Congress could pass a fifth exception, which, would include, if it wants to, certain individuals who are here, for, again, whatever purpose is delineated. But, Justice Roberts, again, spends a good deal of time saying that it's always, been recognized that if someone's here for business or for pleasure, if they are in the United States for business or for pleasure, that they are citizens. So if they have a child while they're here for business or for pleasure, then that's fine. But they're not here for pleasure. The people who come here, the so-called anchor babies. So now we're not talking about people who enter the country illegally. We're talking about people who enter specifically for the purpose of giving birth. So you have these resorts. Again, California, I think, has some other places in the country where Chinese women, for instance, will come and stay for 2 months while they're 7 months pregnant, stay for 2 months for the express purpose of having a baby. It's not, yes, they enjoy their time, their fancy resorts, they spend a lot of money there. So I guess you could say it's for pleasure, but the only reason they're coming while they're 7 months pregnant is so they can have an American citizen child. And so that was not contemplated by the framers of the 14th Amendment. That was never the understanding of for business or for pleasure. If we're going back to jus soli and looking back at common law into England, as Justice Roberts was doing. Find me an example of people that came into the country for the express purpose of giving birth so they could have children citizens. You will not find it, Justice Roberts. It's not in history. So that should have been the discussion. When was there a time when people were coming to the country for that purpose? And if you can't find a parallel, if you can't find anything in the historical context, then you can't use history to justify birthright citizenship. Again, this isn't me being racist or xenophobic. It's not David being racist or xenophobic. David is anything but. I am anything but. I welcome people of all races, of all backgrounds, of all cultures to come and immigrate naturally and legally into this country. Okay. I don't care what country you're from, what culture, your religion, you have a right to legally seek citizenship here, to seek to work here, to seek asylum even. All right. There are provisions for that, but that should not be abused to everyone sneaking in through Mexico or Canada or through the ocean, wherever they're sneaking in from.
Right.
You know, that is not a justification. So we have to look at this practically. We have to look at this. If we're going to use historical context, we have to use the accurate historical context. And there is no historical context for this happening in the United States or really any country, allowing people to come in for the express purpose of giving birth so that their children can be citizens. That hasn't happened anywhere, really. And it definitely doesn't happen. It wasn't in the nation's history. It wasn't contemplated by the framers of the 14th Amendment, the authors of the 14th Amendment. And again, if they had contemplated that, again, I talk about this. I wrote a Substack about this on my Free the Law Substack for We the Patriots USA, that the framers could have, you know, if they intended just anyone who's physically present here to be subject to the jurisdiction, then they could have actually taken the phrase subject to the jurisdiction out of the 14th Amendment and just said all persons born or naturalized are citizens.
Right.
But it didn't say that. It said specifically subject to the jurisdiction. So you have to look at, does that mean? But Justice Roberts is saying that basically anyone who's physically present when they're born is automatically a citizen. Well, then why did it say subject to the jurisdiction thereof? Why did they write that in there? Why didn't they just say all persons born are citizens? So you have to ask that question. That's a tough question that wasn't asked, that wasn't answered, by the majority in this opinion, in this decision. So I have a lot of issues with it. Let me know what you think. I have there's some questions and comments in here. I don't know if we want to address these before we move on to the next one, but
I would just like to do one thing. You mentioned jus soli, and there's what's the other one? So it's jus soli and not jus rex. What's the other one that they brought up? But they mentioned jus soli a lot.
Sure.
Roberts mentioned jus soli a lot. It's jus sanguini, the blood.
By blood. Yeah.
By blood. And Roberts brought up, and I noticed how he wrote, oh, it was all about the king and him giving of himself, with jus soli. So for everybody who doesn't know, jus soli means justice or the law of the soil. And then jus sanguini would be the law of blood. And so, or from blood. And so the idea is, where do you get your citizenship from? Is it from because you're born of certain parents? Well, our statutes, our US code actually says, yeah, it follows the blood. You can be born in another country of parents who are Americans, and that makes you American in and of itself. So there's sanguini, of the blood. Jus soli, Roberts wrote again and again and again about how it was the king would declare that because you are in his protection, therefore you owed a debt. He gave you citizenship. And or because you were in his protection, he owed you citizenship. More so, it was, no, he was going to collect something from the person and make more serfs for himself. So if you came into the country somehow, he was going to try to make you a subject. And so we have a completely different order of government, a form of government than Jus Soli ever existed in, and that got missed. So the basic civics got missed. And with that, I think we segue into kind of some of these questions that we see. Let me put this first one up on the screen, if you can see that. Why exactly were all those citizens who already had all rights at the time of Dred Scott v. Sanford lumped into the 14th Amendment when it was ratified? And so, in other words, full citizens, why were they lumped into the 14th? And then he followed up. He said those then citizens did not need the 14th, but now all are under the 14th. How did this happen legally? Do you want to take that on? Do we want to talk about incorporation?
No, because I don't really understand the question.
Okay. Well, let me start.
So I mean, it was the context, of course, of Dred Scott was saying that slaves were not, what did they say, 2/3 of a person, were not full human beings, were not full citizens.
So, well, Dred Scott, if you remember, Dred Scott said that because Dred Scott was not a citizen, he had no standing before the court. And even though he was rightly owed freedom, he was not, even if somehow he was free, he was not a citizen, and therefore the court gave him no standing, and so therefore his case died, and he remained a slave until he was bought out of slavery by some good folks in the North. What I think we're focused on is what is a doctrine called incorporation, and it is dealing with the 14th Amendment and the supposed incorporation or reincorporation of aspects of the Bill of Rights to all citizens. Because remember, in Barron v. Baltimore in 1837, Marshall, my most hated Supreme Court Chief Justice, said that the Bill of Rights only applied to limit the federal government and wasn't just a statement of rights for all citizens. And so when Barron asked for compensation, some just compensation for the city of Baltimore destroying his business and his wharf, his deep water wharf, by silting it up because they diverted a stream that they needed to do, but in the diversion, it ruined his business, completely ruined, and all the money he and his investors had spent was down the drain. And the city of Baltimore didn't want to make good on it. The state of Maryland didn't want to have them make good on it. And then they went to the federal court under the Fifth Amendment, and the court turned them away, saying, no, this doesn't apply here. It only applies against the federal government, thereby negating the Bill of Rights by practice, not in reality, but by practice, until the 14th Amendment, at which point, basically, because it reiterated aspects of the Fifth Amendment, it reiterated aspects of Article 4 and so forth, they then decided, the Supreme Court deigned themselves to grant that reincorporated the Bill of Rights to everybody. And I think that's what he's dealing with. And so if you can understand, that's kind of the process. Everybody should have always had rights protected under the Bill of Rights, because it is just a restatement of what we have as free people. And that is all right. And then, as we learn in my course, the Fourth through the Eighth Amendments are the process that got set up to make sure that our natural inherent rights are protected. So we have due process, we have warrants, we have um, grand juries, can only be tried once for the same offense, etc. Um, those the Marshall Supreme Court basically said those don't apply except at the federal level. The states can do what they want. They can run roughshod. They can be tyrannical. They can not grant rights. They can be not Republican, etc. And
Okay.
so
David, I'm sorry to jump in. I'm going to have to run here. So
you need to run. Okay.
Yeah, I'm not going to be able to answer any more questions, unfortunately. But you are more than capable of talking for the rest of the time. Yeah, but I'm not sure what is it, Alex? I'm not sure exactly what he was asking there because
I think that's it. It's why would we need a 14th Amendment?
Yeah. Well, no, it's because it was a response to Dred Scott in part in the Civil Rights Act of 1866 because slaves were not given citizenship. The 2/3 of a person thing I misstated. It was 3/5 of a person is what I was thinking of. That's the compromise of 1787, the 3/5 compromise.
Correct.
Yes. That's a whole different thing. But they weren't. But they were basically not recognized as full people. That was my point because that's why they weren't given citizenship. They weren't recognized, obviously, as equals. So that was one of the main reasons the 14th Amendment was passed, or the main reason within the historical context. But I don't know what he's saying. They were already citizens. No, they weren't. They were not. The slaves were not already citizens prior to the 14th Amendment being passed. And if he's talking about the rest of us, or excuse me, white people being citizens, well, it wasn't really passed. I mean, the citizenship part, as far as granting citizenship, wasn't passed for people obviously who are already living here and who are already citizens, white people who had already been citizens or who were born here. But it does contemplate people who would come into the country in the future. Anyway, yeah, he wasn't allowed. Anyway, all right, I'm gonna go. You can talk about the trans athlete stuff some more if you want to, And thank you. And again, I apologize to everyone. Please. We've got to find a way to do this better. Obviously the technology is a challenge.
We have not had this kind of trouble.
Well, we haven't before.
This snuck up on us.
If it's working since I joined tonight, maybe that bodes well but I am a little concerned about future events. We have a big one coming up in September. We cannot have these kind of internet issues while we're broadcasting that event. So we've got to, I have to figure that out. I'll spend some time tomorrow working on that. But thank you all who could join. And David is more than capable of taking it from here. He's the usual host, the teacher of this class, week in and week out. He devotes his time completely of his own kindness, of his own goodness, of his own charity. He doesn't get paid to do this. This is something he does because he really believes in it. He believes in the causes we're fighting for at We the Patriots, but he also believes in the Constitution and in educating people about the Constitution and sharing his knowledge. And he really enjoys it. He really enjoys doing that. So I'm going to duck out, but thank you. And we'll talk again real soon.
Hey, thank you for joining us, Brian. So I just to keep going, Alex said, David expressed it. Dred Scott could have been brought the case if he were a citizen at the time. He was not, so it was not heard. So why were those who were citizens at the time up until today lumped into the 14th? Today, all are, I'm having trouble reading this. All are 14th Amendment citizens. Okay. So to answer that question, Alex, and it says it wasn't passed for white citizens, then if it wasn't passed for, let me show this. If it wasn't passed for white citizens today, also 14th Amendment citizens, I don't see where this happened legally. Hope this makes sense. I get it. The problem, I think, in the disconnect here for you, Alex, and thank you for putting up your questions because you're not alone in your confusion. The problem here is the doctrine, and I'm going to put that in big air quotes, the doctrine of incorporation. Okay. And it's something you want to read up on a little bit, but it's this doctrine of incorporation. 1833, we went off the rails with Baron Baltimore. I think I said 37, but I think it was 1833. We went off the rails. Well, it wasn't the first time, and sometimes going off the rails is not necessarily. I mean, Dred Scott more or less was actually in keeping with the law. Um, Believe it or not, there were big holes, bad holes in the law. And sometimes it is not the place of the judiciary to fix the problem. So, to give you some examples, in Marbury versus Madison, um, Marbury, they said, you've got a case here, you've got a right, you've been denied what is yours by right. Now, in that case, he was a judge. Long story, we can get into that another time. Long story short, he was being kept by Jefferson and James Madison, Thomas Jefferson and James Madison, from getting the document he needed, the warrant, his paperwork that said he was a judge in the federal district court of Washington D.C. And and they didn't want to give it to him because he was a Federalist judge that had been put in there to stack the court. They didn't want to do that. Well, the problem was, though, that the law had been written poorly, and actually the court didn't have the jurisdiction to make the judgment being asked of them. And that was it was actually a correct reading of the Constitution and of the statute by the Supreme Court. So they could correct the law. The Congress could correct the law, fix it. He could come back and get his warrant under the corrected law. He might have been able to go other directions to get a resolution. He didn't bother. He A bunch of these judges let it drop, several of these guys. A place where the court got it right, but didn't give justice because justice needed to really come from somewhere else. Barron v. Baltimore, they actually had the duty to give it. They misused the Constitution. They misused the 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 spirit behind it, the the very premises that our country was founded on. They denied those things in order to come up with their cockamamie ruling. I don't know why they did what they did, but that's what they did. Technically, you could say they could be correct. Could be from one reading because of the way Thomas Jefferson or James Madison introduced the Bill of Rights. He wanted it put into the federal section and not in the state section of the Constitution. Not their place to read one way or the other because Congress said, nope, we're not putting things into place. We're leaving everything separate. And it means what it means. And quite frankly, it didn't mean what the Supreme Court said. So they got that wrong. In Barron, though, what they did was they literally changed our form, in a sense, our governmental form, but they changed our Republican form from that where government derives its powers from free people who donate or delegate their powers to government. Okay. And they basically said, no, only when it comes to the federal government does that happen, but not at the states. And it's like, that doesn't make sense, because in Article 4, it says that the United States shall guarantee to each state in the Union a republican form of government. Well, you can't have that unless all the states, and the assumption was that all the states would be Republican. Key point in Republican is government derives its powers from the free electorate, or the free people who are the citizenry. That is where government gets its power from. And without that power, they've got no authority, none. So if we pull back our power, they've got no authority. We agree that they keep the authority as long as they rightly use it. Government, what they basically said was, no, the states can decide how they're going to run themselves. So somehow, under this thinking, you could have a monarchy in one of the states, but a Republican federal system. And that was never, ever in the minds of the founders. They believed everybody was a republic, was trying to be a republic. And then Madison said, when he introduced everything, that the Bill of Rights should cover the defects of the other states, because under the supremacy clause of Article 6, the Bill of Rights will supersede any deficient or improper state constitutional provisions. So in other words, the Bill of Rights overrides. I'm taking you a long way around because you've got to understand this history. So they say the Bill of Rights doesn't apply to the people in your state, only when it applies, when the federal government is affecting it. It only limits the federal government. Well, then they said that, and they did this to the entire Bill of Rights, is basically what they did. Well, the 14th Amendment comes along, and the idea was we could grab the 14th Amendment and the writers of the 14th Amendment were Republicans in the early Republican Party. And they said, look, this is nothing different than anything we've ever had before. And so this is literally what the author of the 14th Amendment said. He didn't think he was introducing anything new, but all of a sudden that was magic. It applied to the states. Why did it apply to the states? Because it said it applied to the states. So if you read the 14th Amendment, it says that a person born in the United States and subject to the jurisdiction thereof is a citizen of the United States and of the state in which they reside. And then it talks about abridging the rights of a citizen of the United States, and then deals with states and says no state shall make any law which shall abridge the privileges and immunities of a citizen of the United States, and goes on. So what it did was it took away the garbage argument made by Marshall in 1833 and reincorporated all of the rights, which never in reality disappeared because they're unalienable, but by practice were violated. Because everybody said, hey, this is our chance to violate as many rights as we can for as long as we can until they take it away from us. And that's what people did. So you ended up with the slavery, the evils of the worst of the slavery stuff. You had blacks free blacks put back into slavery. You had free whites put into slavery. Everybody was doing evil to everybody because they could get away with it. And so that is kind of why we're now under the 14th Amendment, if you will. That should not be a problem. But because of the doctrine of incorporation, people misuse the 14th Amendment, right and left, as they misuse most of the Constitution, and therefore now claim that because of the 14th Amendment, we don't have certain rights, or we can't do certain things, and the government can do certain things. The federal government is all encompassing because of the 14th Amendment and so forth. And in actuality, that's not true. It really isn't true. Nothing changed with the 14th Amendment, but people want to proclaim that all sorts of things changed. And so that's where I think we get some questions, and rightly so, and some concerns. So what I would ask you to do is, and you can reach back out to me. You can reach me at David Oldham on Facebook, or Constitutional Grounds on Facebook. You can reach out to me personally. My phone number is 918-495-5713. Be happy to talk to you, and answer the questions that you might have, the more specific questions. And because now we have to figure out, okay, where do these various and sundry schemes take us to be able to answer the next questions, because there's too many schemes and they go down different rabbit trails to be able to address that generally from here. So I hope that helps. But really, the 14th Amendment, while making sure that it reiterated just who is an American citizen, and made it beyond Congress's, because Congress was, until the Civil War, until that point, Congress was dysfunctional and was never going to actually address it. Well, we were getting there, but it was going to take another 20 years probably to work it out, roughly, more or less. The war made it happen in 5 years. And then we got the 13th Amendment, then the 14th Amendment, and they came on the heels of each other. And we got the 14th Amendment specifically because of Barron v. Baltimore and Dred Scott, among others. But those are the two biggies, because we were going to make sure there's no question left as to who a citizen was. Could we have done it through statute without an amendment, constitutional amendment? Yeah. Congress could have done it by statute, could have had no problems doing it, but they didn't. And so they went with the 14th Amendment. I do talk quite a bit about unnecessary amendments and so forth. And the Reconstruction amendments are some of those. All of this stuff could have been handled by statute, as was naturalization of American Indians and various and sundry other groups, just done by statute, and done deal. Those people are now American citizens. You can't take it back. And so we didn't need constitutional amendments, but now we have them. So anyway, more than that, I hope I now, men are men, women are women. I think we're clear on that. The real problem I have is that with this particular ruling was they left it to the states to decide. And while they said that the ruling, What it was, oh, you're welcome, Alex. The what what happened with the, and I can't, all of a sudden I'm drawing a blank on the ruling we were talking about. Um, but the gender, the men playing women's sports especially, because we had bad uh, bad outcomes from that. We had a concussion where a male spiked a volleyball into the face of a female, gave her a massive concussion, maybe even broke some bones in her face. Should never have happened, um, and so forth, because there were a couple of states that were, and I think it was Idaho and West Virginia, that were banning that behavior, that men playing in women's sports, to protect women and their right to play amongst themselves alone. Um, what they ended up saying was, no, that is not a violation of the Title VII or Title IX, Title IX in this case. It was not a violation. That was good. That that part was good. Um, so if you ban men from playing with women's sports, it doesn't mean you can't have co-ed, but it has to be marketed as co-ed. It so women have a choice, but women need to be able to play with just women when they want to. That was the entire point of Title IX, was to promote and actually guarantee and encourage women's sports. Okay, right or wrong, indifferent. That was the point. So the court got that part right, but what they didn't do was they did leave it to the states to decide whether states would violate the rights of women by forcing the women to play with men, and thereby basically undoing Title IX in their state. I don't see how that works. And problem that they didn't go into that and delve deep into that part of the case as they needed. So, with that, I think we've just about covered everything that I wanted to cover on those things. Does anybody have any questions or any other comments? Um, while we wrap up, what we do here is I teach at We the Patriots USA every Monday night. We come in and we take a subject and we look at it constitutionally. So that way you can learn the Constitution for yourself, and you will learn about me. I only do original documents. I don't do commentaries from other people. I only do commentaries when they're written by the actual founders, the actual writers, because I want to hear what they had to say about it. So we'll look at that. We learn to look at statutes. We learn to read these kinds of things so that we can affect change in our own either local areas, states, at the federal government, wherever you want to begin. But I try to teach that all politics is local, and so we need to begin locally. And it's amazing what kind of an effect you can have when you start talking to people. Um, we're able to affect everything from not just local elections, but we're able to affect um, our governor's election, attorney general, um, everything from state legislators to the U.S. Congress to uh, state senator or U.S. senators and so forth, just by participating and being able to explain these things. It's amazing how many people will tune in and start looking, and when you're saying things that we all know is true but hasn't been said enough, because we've all spent all of our lives being gaslit by government, media, education, and everything else, and there's just virtually nothing that comes out of them that's true. Then it's amazing what kind of a change you can make when you just start speaking this stuff. And And I want to be that guy that can help you understand you weren't crazy when you started seeing this stuff and they're telling you you're crazy. I can tell you, no, you're not. You're seeing what the founders wrote. Trust what you're reading and when you're reading the founders, because they meant what they said, and it's everybody else who's lying about them. So that's what we try to do every Monday, and ultimately the desire is to get us to a place where we can help affect court cases and the basic practice of government. Okay, because there's the law, and then everybody does whatever they want despite what the law says, and they all ignore it, whether it's the Constitution or the statutes. They just ignore it, and they do their own thing anyway. And it doesn't matter the branch of government that you're in or the level, state, federal, local, doesn't matter. Everybody just does whatever they want despite what the law says. And learning to how we can impose ourselves to get us back to some form of lawfulness is what we're about, because that will help Brian in court help to change things even more rapidly. And I've learned this adage, and it's so true. All politics, all government is downstream of culture. So what we have to do is we have to change the mindset, the culture, and then government follows in whatever part of government they're in. Even the bureaucracy follows when we have a change in our mindset. And so helping to bring that about, that's what we're about, so that we help everyone. Um, how do you join? Well, on We The Patriots USA .org, you can go and you can find their donation page. And one of the levels, and I can never remember, they just changed the verbiage on me, so please forgive me. They You can, when you give, what is it, $25 a month or something like that, a perk is this class. And so you can join us every week, and we will talk about whatever you want. I love to be student driven. And so whatever you guys want to talk about, we'll look into and get it presented. It might take us a couple of weeks to get it prepared, but we will work on getting it there for you. We have some people who've been around for a long time. We've been doing this for a year and a half, maybe a little more now. And so it's been a lot of fun. And at times, it really helps to have new blood come in, where we can have new discussions. Maybe we've already discussed it, but we can have brand spanking new discussions about the same thing. It doesn't hurt anybody to have the same discussions over again, because we all need, even I need re-updating on this stuff, because I don't know every scheme that's out there. And it's good to look at everything with fresh eyes and what the Constitution has to say, so we can learn how to apply the Constitution, because we have a lot more freedom and a lot more rights than they ever told us. They've been lying to us for well over 100 years, and it's time we start dispelling the lies so that we can get back. Well, guys, I am I am so thankful everybody joined in. We are going to do more of these for free from time to time. We will be doing them and getting the word out. But if you will donate and join us on Mondays, we would love to have you. If there are no other questions, I don't see any comments or anything like that popping up. But thank you for sticking around through all of our audio and video problems, and we will look forward to seeing you in class on Mondays, or at one of these free offerings in the future, or at some freedom Constitution loving event around the country. Thank you, guys. You have a very good night from We the Patriots USA and constitutionalgrounds.com. Have a good one.